You are listening to the Complete Developer Podcast, the podcast by coders, for coders, about all aspects of creating your best life as a developer.
I'm Will, the accomplished developer and aspiring software architect.
And I'm Beej, the advancing journeyman developer.
Complete Developer Podcast is supported by listeners like you. We are now on Patreon at www.patreon.com/Complete Developer Podcast.
I am the law! We've brought on lawyer Gary Nissenbaum to discuss the law in the context of software development. We'll delve into common legal mistakes developers make, then have a longer discussion about intellectual property and licensing around using open source. But before we get started, Will, what have you been fighting this week?
Well, in addition to your intros, I had a very funny situation happen to me Friday night. It was shocking when it first happened, but then it was kind of funny after the fact. I tend to stay up late on Friday nights a lot and kind of work on content for the podcast and other stuff. And a little after midnight, I was like, okay, I'm going to go to bed. And I, thought I'll hit the bathroom down here so I don't wake Kathleen up, and then I'll go upstairs. And while I was in the restroom, out of the corner of my eye, I saw movement, and I looked over, and a snake came under the bathroom door. And it's black and red, and I'm looking at it, and I'm like, well, it could be a king snake or it could be a coral snake. And I'm trying to remember the little stupid rhyme that we were taught as kids. And I'm looking at it, and it's like 4 inches long. It comes up there, and I kind of kick at it to try to run it away. And it kind of coiled up and struck at my shoe, and I'm like, oh man, he's aggressive. Finally scared it off, caught it in a wastebasket, had to go and, go to Google Images and try to figure out what this thing was. And it was actually a scarlet king snake, which was a relief.
Don't you mean sending me a video of it?
Yeah, go ahead.
Like, what is this?
Yeah. I was like, I sent it to you, and I sent it to a couple messages to other friends of mine that, might know off the top of their head, because I was racking my brain. I couldn't remember it. I'd finally figured out, okay, this thing's not poisonous. And I caught it and took it, dumped it outside. My wife was irritated that, she's like, why didn't you kill the snake? We don't need that around here. And I'm like, well, he's, it's not poisonous. He's just doing his thing, So that's just an example of the serious mortal hazards that we run into as podcasters. So, how about you, Gary?
Well, first of all, I want to say hello to all your listeners. I'm really honored to be on this podcast, and thanks for the opportunity. I'll tell you that, how it is when you have a dysfunctional relationship, and every time you come home in the evening, you have the same argument over and over and over again. I am in that, and I can't get out of it. And basically, it's an argument that I'm having with a woman named Siri. And every single night, you know what she says to me? She says that she wants me to update my iOS to 10.3.3. Mm-hmm. And I want her to have a little screen that says no. There's no such thing. The screen says later. And so when you click later, then it says, will you remind me later? Which means we're going to have the same stupid argument over and over again every single night. So the next night and the next night and the next night, it just never stops. And I understand that there's going to be an iOS 11, and that's great. But now, as I understand it, that might not work with all of my apps. And I don't mean my apps for social media. I'm talking about things that I need for the security of my law firm, like Auth Anvil and things like that. So I just have a feeling that I am caught in a dysfunctional relationship. But you know what I do after I get through this and I'm all frustrated and I want to listen to some music? I go to my other little friend Alexa, and she knows just what to play for me. And everything becomes smooth, and I'm soothed, and everything's wonderful. So that is my life these days.
That's awesome. My mom actually has the iPhone 4, which when we got it for her she had the newest phone of the entire family. She was so proud, and she hasn't gotten a new one since because she's so proud that she had the newest phone in the family at one point in time.
Right. Planned obsolescence, that's what they call it.
Yes.
So my life the past couple of weeks has been all meetings. We're about to start the next phase of a project at work, so we've been in planning meetings, getting ready to build an inspection piece to go along with the online registration that we built earlier this year. Less fun note, I have a stress fracture on my left second metatarsal to go full med student, so to speak.
Or if you want it in my form of speech, he done broke his foot.
Yeah, wow. Pretty much. Basically, that's the bone that connects to the second toe on my left foot, has a very small fracture from overuse. And as you guys know, I have been trying to lose some weight. That was one of my goals for this year. So I've been doing more walking and I actually started doing some jogging, which I think I stepped on something, maybe an acorn or a rock when I was out jogging with my dog. And so yes, I broke my foot exercising and I'm going to be in a boot for the next 4 to 6 weeks.
Man.
That said, though, thank you. That said, though, I have something that kind of relates to medicine, exercising, and the law. So let's go ahead and play the music. This week for IoTs, I have an article from IoTlaw.com titled Wearable Technologies Change Due to New Medical Device Regulations. With the prevalence of devices like Fitbit and smartwatches tracking vital signs and other medical information, they're starting to be considered medical devices. This article discusses the new European regulations on medical devices. Now, most of these regulations focus on devices that are already considered medical. Some accessories not previously considered medical, though, may now be classified as such. According to one regulation, which is Directive 2007/47/EC, and I'm quoting here, software, when specifically intended by the manufacturer to be used for one or more of the medical purposes, is a medical device. Now, these medical purposes include diagnosis, prevention, monitoring, treatment, or alleviation of injury, disease, or disability, as well as investigation or modification of anatomy or physiological processes, and this even includes birth control. So it's a pretty neat article. I suggest you guys go take a look at it just to kind of get a better understanding of where some of the wearable technologies are going, and I'll include a link to that in the show notes. Will, who's talking to us this week?
Well, we grabbed a tweet from Brandon Paget. It says, do you guys have your processes and tools documented anywhere for time management goals and tasks, etc.? You want to answer this one, Beach?
Yeah, I'll go for it. Brandon, that is a great question. We've been talking about writing some blog posts with that specific information that goes kind of beyond what's covered in each episode. We're also building some additional training materials that'll be coming out next year. I will suggest that you check out our weekly emails because they include more information than is even in the show notes. And you can look at those as well because sometimes when we talk about a thing on the show, especially like how to plan or how to use a spreadsheet for planning, we'll include links or even images to describe what we're talking about in the show notes. But we really want to thank you for the tweet and send us a direct message or email with your address because we've got a Complete Developer water bottle just for you. Guys, if you'd like your very own Complete Developer water bottle, leave us a review on iTunes or comment on the website or any of our social media. We post all our episodes to Facebook, Twitter, LinkedIn, and Google+. We're also on Path and Tumblr. And now you can check out our Complete Developer Network Slack channel. To join the conversation, go to the Slack sign up on our website.
Gary Nissenbaum is a managing attorney with the Nissenbaum Law Group. The Nissenbaum Law Group is a boutique law firm with offices in New York, New Jersey, Pennsylvania, and Texas. It has an emphasis in business law, including internet, app, video gaming, and entertainment matters. The firm's clients range from true e-commerce websites to brick-and-mortar companies that utilize a website solely as an adjunct. It handles a range of internet law matters such as drafting electronic contracts, protecting against universal jurisdiction, addressing privacy issues, and attending to the internet's distinct intellectual property concerns related to copyright and trademark. The firm also practices in the related field of technology law, such as representing software development and technology companies, including those that sell computer-based technology worldwide. The firm has handled matters that involve software development and digital technology projects in many regions of the United States, as well as in Europe, the Middle East, and Asia.
Also, I want to point out that Gary is a published mystery novelist, Tai Chi instructor, and a huge Star Trek fan.
TOS.
And,
Star Trek TOS, my friend.
Oh,
That's the
TOS.
one. Yeah, let's be clear.
All right. So I have to ask, I've really gotten into the new show, The Orville, and I know I didn't tell you about this up front. Have you seen that show?
I have not. Tell me about it.
All right, it's Seth MacFarlane from Family Guy, American Dad, and in my opinion, it is his attempt at moving from comedy to serious. So it's kind of a comedy version of Star Trek, but they cover some serious stuff. It's 2 episodes out, and I'm hooked already.
There was a movie.
It's really good.
There was a movie like that, was there not?
Yes, there was.
Galaxy Quest, I think it was called.
Yeah, that was a great movie.
Right. That I enjoyed, so I will definitely check that out. Thank you.
Yeah. So before we get started, I usually like to ask our guests how they got into programming. However, given that you're a lawyer, that doesn't exactly apply to you. So how did you become interested in law, and specifically in law related to technology?
Well, I've been an attorney for over 30 years. And in that entire time, I have concentrated my practice in commercial law, business law. When I opened this firm, and we're now at sort of a fluctuating number, about 8 lawyers or so, it was right around the dot-com boom in the late 90s. And we go where the clients take us. So if the commercial transactions and the commercial litigation that's going on nationwide is digitally oriented, then that's where we're going to go. And we sort of worked in that field easily for the last 20 years. A lot of what we've done is we've evolved as attorneys. So in the 90s and the early 2000s, we might be involved in purchase and sale of a business and non-disclosure agreements, copyrights, trademarks, things like this, the very basic things you need for this world. We are moving now into far more sophisticated realms. We do a huge amount of work with apps, video games, entertainment law, a lot of it having this sort of intellectual property aspect to it that really is so important. And I will tell you that we've learned a lot from our IT clients. And if I could just take a moment and give you one example, which I think your listeners might find interesting.
Please do, yeah.
We were involved in a major project in which we were essentially keeping everything organized from the perspective of the legal documents that had to be in place in the different time periods. So we would attend the scrums that were being done to put together the software on a massive scale. This was a $24 million project. And we watched our IT client conduct these scrums, and we saw a whole new way of managing people and managing projects. And we began to understand that there might be an overlap, that a law firm might have its own scrum. And because there's a lot of things that we do that are similar in terms of large transactional projects and large litigation matters that have a lot of moving parts, and we have to have the team all going together at the same time. And so at this point, we have a scrum every other day with some minor exceptions. And our scrums are the one difference we have from the way it's normally done in the IT world. I know the way you do it is as quick as it can be done within reason, and then people get to work, and so it's efficient. The way we do it is we want to go through every single case in the office, the whole thing. We have an Excel spreadsheet up, and we're literally going right down the sheet, and the entire team, all 8 of us, are reporting on what we're doing, commenting on it, explaining some other cases or things we've done in the past or new developments in the law that we might use. And so you're literally going over the entire thing every 48 hours, and it has revolutionized our practice. It's made us incredibly organized and incredibly focused, and we're ahead of the curve in so many ways. Lawyers are known for constantly asking for extensions and constantly, sort of being blindsided blindsided by deadlines and things like that, and having to run, at 100 miles an hour to catch up. And that doesn't normally happen with us. With us, we're so far ahead of these deadlines because we're talking about them every other day. And it really has created a wonderful morale in the office and enthusiasm. So I have to tip my hat to the IT world and to the developer world and the people that do what you do, because you got something really right there, and I wish more lawyers would take you up on it.
I really enjoy the Scrum process. We do that where I work, and when we do Scrum, we do what I did yesterday, what I'm doing today, and what impedes me or keeps me from doing my job. Do you guys find that you're able to help each other out when you do that?
Absolutely. And the reason it works is that unlike a typical law firm in which you, let's say, have eight people who are going in different directions, somebody might be practicing matrimonial law, somebody might be practicing criminal law, and then somebody might be doing the commercial stuff. With us, since it's a boutique firm and we're focused in this area, this commercial law area, we all can be interchangeable in that way. We all can understand what's going on in all the cases and contribute. So whereas a transaction might have gone well, but now there's a problem with one of the parties and someone's going to sue, the people who are in our litigation department are basically aware of the case, have heard its entire anatomy and its arc and its evolution from the point where the contract was being drafted. And so when the contract is breached, it's not a big leap for a litigation person to step in. And then when a litigation person is settling the case, when it's over or about to be over, we bring that transactional person in, and they lend their transactional acumen to putting together a settlement that will hopefully be bulletproof, or as bulletproof as we can make it. So it's that synergy that we're seeing with the Scrum.
Yeah, it sounds like you guys are doing like the true Scrum attitude, whereas within development, everyone is a developer, but with you guys, everyone is a lawyer. And like one person in the development world may be more of a front-end developer, more of a back-end developer, more of a quality assurance person, but everyone is a member of the same team of equals. And that's really awesome.
And not to belabor it, but then what we try to do is expand that to our clients. So the clients we have are savvy. They understand how to communicate with us digitally. And so what we try to do is have the clients not sort of be part of our Scrum, but have a Scrum with the client. So where we try to be reachable and have them ask us questions and tell us where they are in the transaction, let us tell them where we are in the transaction, and share documents and share even share computer screens with Skype and things like that, so that we're sort of doing the same sort of thing, a little different, with the client in a collaborative way.
That's really neat that you guys picked up something from development and were able to apply it to what you do as lawyers. That's
and modify it to fit that mold. I mean, you didn't just slavishly follow the way developers do it, because you kind of have a little bit more complex situation, and a situation where things are a bit more permanent than software. And so you kind of have to spend a little bit more time up front, and it's good that you guys recognize that and were able to adapt it to fit
my
that.
profession is becoming like your profession. Your profession is in the lead. And so the very thing that you do, which is speed, for example, you don't go from committee meeting to committee meeting to committee meeting. Before you know it, you don't even know why you're in the meeting or what the point of the meeting is. You're developing a web application, you're developing some code, and all the parts have to be together, but you have a deadline and it has to move. And you're not respecting state boundaries. You're not respecting national boundaries. You're getting a team together of people that are halfway around the globe. This is what the IT world has taught us. This is what developers have taught us. And a lot of our law firm is patterned after that, since a lot of the transactions that we're involved in cross state borders, sometimes involve others who are outside of the country. And we can't do this in a slow, plodding sort of 1950s way. It's not a button down way. We have to be nimble and we have to be moving as quickly as our clients, and our clients are moving pretty quickly. And I must say that technology has helped us. I mean, as you said in the introduction, we have offices in New Jersey, New York, Pennsylvania, and Texas. Well, those are not all contiguous states. Texas is 1,000 miles away, and yet we're able to seamlessly work the whole thing together because of digital technology. Without digital technology, the firm would look completely different.
No, that makes perfect sense. So, kind of jumping into things, what are some common misconceptions that developers have about lawyers?
Well, I think that what they generally believe, because people have told them this, is that lawyers don't understand business. I can't tell you how many times I have heard that. I hear it from accountants. I hear it from clients, that lawyers come in and the deal is killed. It's really the opposite. It's more along the lines of if the deal gets killed, maybe that deal should have died. Maybe that deal was so dangerous that you were driving down the highway 100 miles an hour with a blindfold on. And yeah, you might have been able to get to the finish line without a breach of the contract and some disaster happening, but it's unlikely. So what lawyers try to do, what good commercial lawyers especially, but other lawyers as well, try to do is make the deal happen, effectuate it, use creative ways of doing that. A lot of what we're trying to do is collaborate even with the attorneys on the other side of the transaction. Not to say that we're taking their side. We're vigorous, we're aggressive, but the point is that if you have someone on the other side of the transaction who wants to get to the goal line, and it's just a question of how we're going to get there and whose client is going to be advantaged by various provisions in the contract, that's a good place for us to be, and that enhances the business. It doesn't hurt the business.
Yeah, I've had that experience before, and I've heard people say the same thing. It's the lawyers came in here and they screwed up this great deal we were going to have, and they had all these objections, and it's sort of like a home inspection. It's like if they find mold and the foundation's already cracking and it's starting to slide down the hill, like you don't want to buy that house.
A lot of it comes down to humility. If a lawyer walks into a transaction and thinks that they know more than the client about the client's own industry, it really won't work. It's dysfunctional. You have to have the humility that you're asking questions, that you're listening before you speak. There's an old saying, don't just stand there, do something. But in law, it's more along the lines of don't just do something, stand there. Think. Don't react, respond. And that's kind of where we go with it.
Yeah, actually, that reminds me of what an attorney friend of mine told me. He was like, unless you are absolutely certain, you don't jump into the situation. Like you stand and wait, because he goes, there's no deaf mutes in prison. And that's what he told me. He goes, you can go check. That was his advice to me when I was young and a little bit more brash. So it was actually pretty reasonable. So I guess the avoidance of mistakes is a big deal. So what's the biggest legal mistake that developers commonly make? Insurance.
I bet very few of the people listening right now thought I was going to say insurance. But the fact is that when we talk to developers who have their own business or even have their own business on the side where they have multiple jobs and things like that, and we ask them, are you insured for what you are doing? So many of them either are not insured, or if they are, they don't know the terms of their own insurance policy. The fact is that being a developer is a business, and people in America are subject to litigation for all sorts of reasons. You were discussing a while back the fact that in Europe, certain coding would have to register if it's used for medical devices. And so now let's say somebody has a heart attack and they're using a medical device that's supposed to monitor the heart, and it doesn't do it, or at least it's alleged doesn't do it the right way. Well, the developer could be in that lawsuit. I'm not saying that the developer is going to be the primary target, but the normal way these things go is you bring in everybody in what's called the chain of causation. So number one is getting the right insurance product and making sure that it applies to the things that you're doing. Second thing, I would say a big mistake is not reading contracts. We're all used to the I agree, I don't agree, and just click I agree and we move on. But the fact is that those are contracts you're binding yourself to. And I find that people generally, if they see a contract that is written in 10-point font, and it's not something that they can easily read because a lot of legal language, they just assume that somebody vetted it somewhere and it's fine. And it's not fine, and it has to be reviewed, and a lawyer should be looking at it. So my point is that you have to be careful, because the thing that's going to get you is the thing that you didn't pay attention to. The thing you're focused on generally is not going to be the problem.
I always tell people about the episode of South Park about the EULA for the iPhone, and where I think it's Kyle that ends up getting it's Kyle because his dad's a lawyer. Where he ends up getting taken by Apple and turned into like the human centipede type thing, and it's you signed that you would let us do this.
And the funny thing is that it's not so much that if you sign some kind of contract, they call it a contract of adhesion, where it was impossible to change, it couldn't be negotiated, you didn't really have an opportunity. It's not that there aren't defenses to it. Of course there are defenses, and you might even win. But by the time you get to court, by the time you get to trial, it's expensive, it's time consuming, and even setting all that aside, it's draining. I tell people, do you really want to be a professional client? I mean, don't you want to do your job and not have to worry about the things that I do? And in order to do that, it's so much better and so much less expensive to head off the problem by negotiating the contract up front than to sign something, and then the first time you look at the enforcement provisions is when it's breached.
That makes perfect sense, and it really leads right into the next question that we had for you, which is, what are things about contract law that are not well understood by lay people?
Well, I'm glad you're asking me this, because this is really one of our pet peeves, is that people focus on price and payment and things like that, and they're not focused on some of what they consider to be boilerplate, but it's really not boilerplate. So let me just jump into one of the big ones, which is, if you ask somebody, do you have a choice of law provision? Generally, they know what you're talking about. You're talking about the state's law that applies to this contract. So when it's enforced, it's under a certain state's law. When it's breached, it's under a certain state's law. And we all understand that. But then when you ask them, do you have a jurisdiction clause? They have no idea what you're talking about. Ooh. And the jurisdiction clause is as important as the choice of law, and it's different. It's not the same thing. A jurisdiction clause means that the person who signs the contract consents to be subject to the jurisdiction of the courts of a particular state in a particular county, a venue, and that they will be served, let's say, this is a variation, by regular mail, not by hand delivery. So if we have a contract and we're in New York, and it's all signed, it's all great, and then 5 years later when it's being enforced, all the parties are scattered around the country. What am I supposed to do exactly? Find the sheriff in each of those counties out in the Midwest or the South, and I'm supposed to then open a lawsuit there to have it served there? It's a very laborious process, and sometimes the client just can't afford it, and it's a waste. So I should be able to have jurisdiction where I want it, where the contract, let's say, was signed, or some other reason that should be the venue, and then it's rock solid and everyone's consented to it. Another one is the difference between confidentiality and non-disparagement. Those are two different clauses, and you have to understand the difference. Confidentiality means that you're going to maintain secrecy of certain information. And usually those are very broad provisions, frankly so broad that sometimes people don't even know what they have to keep secret, so that what they're told is just everything you learned here, keep it secret, which generally is really overkill. But there is something also called a non-disparagement clause. And non-disparagement means that you will not say anything negative about the other side of the transaction. And that's different than confidentiality. And in the age of social media, in the age of anonymous posting, in the age of the ways in which trolls can just destroy businesses, a non-disparagement clause is very important. And in fact, it's become a focus of litigation because there is a counter-argument to say that non-disparagement clauses should not be as broad as we normally would write them, because the counter-argument is that if somebody has a legitimate point that they need to make as a whistleblower, for example, or in the public interest, or they just want to exercise their First Amendment rights and things like that, that the non-disparagement clauses sometimes can impede basic rights that, for example, employees might have in the workplace to talk about the conditions there. And so this is a very, very interesting and cutting-edge area of the law. But again, these are provisions of contracts which are misunderstood. They're not the same thing. Liquidated damages. That's another one.
I'm going to have to look into the non-disparagement, because, with having a podcast, we talk heavily about what's going on in our personal lives, and a lot of our examples come from either current or previous jobs we've had. So that's something we should consider.
Well,
I'm pretty paranoid.
You need to review the contract that you signed. Do you know all the contracts that you've signed in your career? Do you have copies of all of them?
I've got copies of most of mine over the last 8 or 9 years.
Good.
So
yeah,
that's important.
And that's not because I'm organized. It's because I'm a pack rat.
Well, join the club, because I'm one too. I'll give you one more, and then maybe we can move on. Liquidated damages. Most people don't know what liquidated damages are. Basically, when you have somebody violate the law, you can have a situation in which the law is clearly violated, but there's no damage. And if there's no damage, then how do you have a remedy for that? And so liquidated damages are where someone says, listen, if this is violated, here's what you have to pay, or here's the formula by which we'll determine what the damages are, without regard to whether the actual damages. So those are three that I think are important and are misunderstood.
Okay. So can you explain a little bit more about how non-disclosure agreements typically work? Like how is that all set up?
One of the interesting things about contracts, that people can waive their constitutional rights by signing a contract. If you ask a person in the street, is it possible to waive your constitutional rights by signing a contract? Most people would say, well, I don't think so. That doesn't sound right. It's actually the other way around. You have a First Amendment right to comment on things, and the government should not be stopping you from doing that. In this case, the government being the court system. But if you sign a contract that says that if I tell you about my idea, even though my idea is not developed to the point where I could copyright the code, or I could copyright the software, or I could copyright the book, it's just an idea. It can't be copyrighted. It's obviously open to the public. So if I tell you, you could just take it. I understand that. You're signing a contract that says you won't do that. Copyright is expression of an idea that's being protected. Copyright is not the idea itself. And that's an important distinction to make. So a non-disclosure agreement is saying, yes, as to the world, I cannot protect this idea as an idea without some expression. However, between two parties that are signing a contract, I can waive that right. And I can say, and you can tell me that you will not disclose what I'm about to tell you. Even though normally you could, you can't, because you're signing this contract. And one more thing, which is, if you have an organization sign a non-disclosure agreement, let's say it's a company and there's 13 people in the company, what you may want to consider, and I understand that sometimes it's just not feasible because you have unequal bargaining power, you have somebody who's listening, but they don't even know what you're going to tell them, so they're not going to sign anything. I get it. Non-disclosure agreements are difficult to negotiate. However, in the right circumstances, if you can not just have the entity sign it, the entity that you're giving this information to, but also the individuals who are associated with that entity who will get the information sign it as well, that is an added level of protection. So again, not always appropriate, but in the appropriate situation, it's a good idea.
So is that basically just to make it easier to pierce the corporate veil?
No, it's for what if they leave? What if somebody moves on? So the company goes bankrupt, or the company is dissolved. I can sue the company all I want, but if it has no money, if it doesn't exist anymore, so in other words, all the protections I have are with the company, not with the individual. So I want the company to sign, but I also want another page in which the individuals bind themselves as well. Having said that, I know a lot of people out there are sort of rolling their eyes because in the real world, when you have a situation where you're disclosing an idea to somebody who you want to, for example, invest in your idea and that sort of thing, you don't have that kind of bargaining power always. And the idea that you're going to have 13 people sign it personally binding themselves might be pie in the sky. So believe me, I'm practical and I understand you can't always get that. But I just want to put it out there so that the people understand there is a difference.
I understand that. That makes sense. Following along with this, what rules should developers follow to make sure they aren't violating their own employer's intellectual property rights?
Well, first of all, let's go to the gold standard. The best answer to that would be if you're in a situation in which your employer has no issue with you doing work on the side, so long as it doesn't compete with your employer, so long as it's not undermining your employer, certainly as long as it's not a customer of your employer, obviously. But they're okay with you doing things on the side, and they tell you this. Get it in writing. Prepare a contract and have them sign it, or at the very least, a strong, legally sufficient letter that they acknowledge. And because memories are short, and if somebody tells you that you're allowed to do moonlighting, a year from now, when you're making a lot of money moonlighting, and the company is run by somebody else, or your manager has moved on, it's a new manager who may feel differently, it's going to be very hard for you to prove that anybody ever said that to you. So that would be the best, is have the employer actually consent to it in writing. The second best would be for you to review the contract that you're signing. If there's no contract, review the firm policies, look around you to see what kind of situations other people are in, and if they are moonlighting, is it being done in secret? Is there a culture of this that's sort of under the radar? That's not a good thing, and you should be very careful of that because you could be pulled into something that could involve a mass lawsuit, frankly. So the bottom line is get the employer to give you a contract if possible, or at least a letter confirming that you can do this. If you can't get that, read the contract you're signing, parse it out, possibly negotiate it when you take the job. And if none of that works and the employer has a moonlighting policy where they don't want you to do it, the legal advice I would give you is, even though this is not real legal advice, I'm being facetious, the advice I would give you is don't do it.
Well, makes perfect sense. Speaking of moonlighting and side projects, what rules should developers have to protect their own intellectual property rights when they're working on side projects, aside from what they do for their employers?
Well, let's talk about the one that people forget about first, and then we'll move to the ones that I think are the more obvious. The ones that a developer usually doesn't focus on when they have a project they're doing and they have people working on it, usually as independent contractors, sometimes as employees, is that they need to get what is called an assignment of all the right title and interest to the project and have that assignment given to them. Now, obviously, nothing I'm saying tonight can be seen as legal advice since I don't know what state the person who's listening to this is going to be in, but I certainly can tell you as a general principle that one of the quirks, one of the misunderstood aspects of intellectual property law is that if you pay somebody to create something for you, such as to code for you or to create a web application for you, you don't necessarily own it just because you paid for it. And that's really important. If the person put the thing together, even if they were paid, it is not completely clear, although it's likely, it's not completely clear that you own it just because you paid them for it. And so what we like to do is have people sign something called a quit claim assignment. And your listeners should write that down. Look it up on the internet, a quit claim assignment. And a quit claim assignment is a large legal term for a very small thing, which is whatever I own, now you own it. So if I had a claim, I'm quitting my claim. That's really all it means. It used to be used in real estate when you would convey real estate and people didn't know exactly what interest they had, but they wanted whatever they had, they wanted to convey. This is what we do with intellectual property now. So that's number one. And also your listeners should pay particular attention to, as long as we just raised it, whether the person working on their projects are independent contractors or employees. There is a major change in the way states are enforcing those regulations, determining who's an employee, who's an independent contractor. I'm assuming most of the people listening to this know exactly what I'm talking about. There is a move toward classifying people as employees unless there is clear evidence that they're an independent contractor, and there's a test that's used generally for that. You have to pay attention to that, because if you're paying somebody as an independent contractor without taking out withholding, without having payroll, and it turns out they meet the test to be an employee, that can result in liability. Another thing is they have to have restrictive covenants for the people that work on this with them, because they don't want to create their own competitors. And then the final thing, which I assume is what you were referring to, and we'll talk a little bit more later, is good, solid copyrights of the software, of the web application, whatever it is you're creating. We want to copyright that code. And that's one level of copyright. And then another level of copyright is the graphics, the way the people can see the work that you're doing when they open up a website. That is a separate copyright. And of course, intellectual property also includes trademark, which is how a product or a service is identified in commerce, and that should also be protected.
So I guess since we got into the trademarks thing, can you explain for the audience the difference between patents, trademarks, and copyrights? Because I know a lot of people get those really tangled up.
Well, sure. And just to restate the basic premise that I think most people intuitively know, but let's just lay it out there. You're not obtaining federal registration of an idea. An idea is not something that you're protecting through a federal registration of a copyright or a trademark. What you are protecting, this is really important, you're protecting the expression of the idea through a copyright. You are saying that this idea that I have, and ideas are open to people. People can have the same ideas that I have. But the way that I'm expressing it, the way I am expressing it verbally, the way I express it through music, the way I express it through books, movies, and frankly, code, through apps, the websites, that expression is what is being copyrighted. There is a common law copyright generally, again, this is according to what state's law applies, that you have even if you don't register it with the federal government. The thing is that if you don't register your copyright with the federal government, you don't have the enhanced rights that the copyright statute will give you. And that's really the whole key here, is that you want to have enhanced rights. You want to be able to say, you know what, you violated my copyright, and now what I want is I want my attorney's fees paid. I don't want to have to show that I had damages. I want the damages to be in the statute. I want the damages to be presumed, that sort of thing. And in order to do that, and if there's one thing you remember from this podcast, at least my part of it, that I want you to just drill a hole and just kind of fill it in with this information, it's really important. You should register your copyright with the federal government within less than 3 months of publishing the copyrighted material. If you don't do that, if you miss that 3-month deadline, you have a serious impediment to asserting the copyright rights. You still may have your copyright, but the remedies are much less. And that's really important. Now, there are exceptions and there are other aspects to it. It's more complicated than that. But just focus on the fact that in this one respect, the law has a really, really short time deadline. Setting that aside, trademark is how you're identified in the marketplace. Generally, there are states' rights of some type when you are identifying yourself in business. There are common law causes of action you can have for unfair competition and trying to trick customers into thinking that one business is another's. That can be a consumer fraud. There's all sorts of things like that. But the tried and true, the basic method of protecting this is a federal trademark registration with the federal government. And in order to do that, what you need to do is you need to be aware that you're trademarking something for a purpose. And this is you talk about misconceptions people have. This is a big one. Lexus is a car company. Lexus is an information technology company. How is it possible that you can have a trademark for Lexus and Lexus? How can they both have trademarks? And the answer is, and this is the key, is that you're trademarking for a type of use in the commerce. So Lexus, the car company, is trademarking for using that name to sell cars and probably do attendant things that are involved with that. And Lexus, the IT company, is doing it for IT purposes and surrounding purposes like that, legal research, things like that. So that's an important thing. And the word for this, if people want to get into it to this extent, the word for this is classification. The government has classifications for the trademark. And those classifications are the key to everything. Because if you're in the wrong classification, you're nowhere. And you could be classifying your trademark for something that you just don't do, which is a problem because you're telling the government it is something you do. So that's a problem. But it's also a problem because it's hard to enforce. How do you enforce that if you're not using it properly?
That's something I hadn't even thought about.
Yeah.
Well, this is one of the problems when you have people going on the internet and seeing that for a small nominal amount of money, some website will get you your trademark. Yeah, nominal amount of money to get the trademark is fine, but if you read the fine print, they're saying we're not lawyers and we're not giving you legal advice. Well, what I'm talking about are the sorts of things that a lawyer would look at. And I've had numerous clients. In fact, I don't want to go into the details, but I had one young woman who it was very affecting because she burst into tears because she thought she had gone on one of these websites, registered what she thought was her trademark. And when I looked at what she had done, I did a search. There was no trademark. It was an intent to use, meaning that she had a certain period of time to register it. And that's all she was doing was preserving it. And then she had blown the deadline because she thought it was a trademark. She didn't think it was an intent to use. So she had wasted all that money and not had a trademark. And that's the sort of thing that we as lawyers try to instill in people is that, there are no shortcuts. When you're protecting yourself, you have to do it in a thorough way. And finally, patents. You're talking about design patents. You're talking about utility patents. Those are the ones that, generally speaking, are the ones that developers are going to be using. The design of code and the application that the code represents, the utility, the use of the application that the code represents. The takeaway there, I'm not going to go into this. This could be a whole hour on itself, and I'm not going to do that. But one sentence I'm going to say about that, which is the United States Supreme Court has consistently scaled back the protections for web applications, code, the things that you develop. So the idea that you're going to be able to get those kinds of patents for what your listeners do, that's becoming more and more difficult. Not impossible, but more and more difficult.
Okay. That's interesting. I'm sure we have people that are building new things or building their own things, might want to look into that more. Speaking of United States law, how do international intellectual property laws intersect with U.S. laws?
Well, there I really have a great answer for you because, everybody has some gripe about how the government works. This is one area where the government did a phenomenal job, I must tell you. There is something called WIPO, World Intellectual Property Organization. And it has a lot of different moving parts and a lot of things that it does. One of the things, I'll just give you an example, is they deal with domains, web domains that are violative of someone else's trademark. Now, normally we don't think of a domain as violating a trademark as such. And so using a domain that has someone else's name in it might not technically be a trademark violation according to what the circumstances are as such in the normal way we think of trademarks. But it could be cyber squatting, and it could be a domain violation that the World Intellectual Property Organization is going to investigate and determine using the Uniform Domain Name Dispute Resolution Procedure, which is the UDRP. So the concept is that if you are using a domain to create confusion, there is a mechanism to deal with that through this organization. Second thing is something called the Madrid Protocol. And the Madrid Protocol is a way that all these countries have gotten together, and I'd say you're talking about much of the developed world has gotten together and signed this protocol. And what it means is that if you're an American, for example, and you go to the USPTO, the U.S. Patent and Trademark Office, and you are registering your trademark, you should be able to then have that registration also apply in other countries. Now, there's a procedure, different forms, there's filing fees. It's more involved than just having it registered here in America. But the key thing is that you don't have to go to those countries to do it, which is the way it used to be. You can do it through our government, and they can do it in other countries through their registration process and do it in reverse. So it's a very, very good system. And it's one of those systems that's sort of the future, I think, of law, where you're not just crossing state borders, but you're crossing nation borders. And
that's really awesome.
Yeah, and we have my firm has actually done some of this, and we've actually enforced, through the UDRP and some of those things, and we've also dealt with the Madrid Protocol. And I got to tell you, it's impressive that they were able, this many countries were able to sort of get together and agree on something that would help every business in every one of those countries. And it's really something where we should applaud government.
Now, as a government employee, I understand that.
Good. Talking to the right guy.
Yeah, no, I get you there.
So we had another question in here, and this is kind of something we ran into. I don't know, Beach. I guess it's been 5 or 6 months at this point.
Yeah. This was a website that I built, and you were hosting.
Yeah, for a friend of ours, and it's WordPress, and so what happens to WordPress is that it gets breached. WordPress is my favorite web-based remote shell, and yeah, so it got breached through an anti-spam plugin, and somebody used it to put up knockoff purses, for sale. And so we didn't see that was going on, and then we got an email about it. And it was like, hey, take this down. We know, and it was from, it's from a law office. It's like, we know this is the result of a breach. So, here's your, I forget the exact wording, but here's your fair warning. Of course, heck, that was kind of nice that somebody caught that and, let us know that there was a problem. So we, turned around and fixed it pretty quick. But what should developers do when they get a cease and desist or something similar from a corporate attorney in regards to a website that they manage?
Well, I mean, it's not a long stretch for me to say that you should hire a lawyer who practices in this area, because every one of these is unique, and they're the obvious legal precedents that are being discussed might not be the only legal precedents that people have to understand. Going beyond that, though, your example of somebody having gray market goods, knockoff goods, that letter should be taken seriously. And if you actually are involved in selling those things, you could be brought into a massive federal lawsuit, and the damages could be unbelievable. So we've kind of seen those in action, and I would say you should take them seriously. But going beyond that, the more that is an unusual situation in my experience. The more typical situation is a Digital Millennium Copyright Act, DMCA, takedown notice. And that's interesting, and I think your listeners might find this relevant because, there is a lot of misconceptions about what is the DMCA and how does it work. In essence, the DMCA says that in the digital world, we want to protect copyright, but we don't want to destroy and undermine the ISP, the website host, that sort of person, the one who's in the middle of this, by having them deal with successive infringement lawsuits just because something that was on their site or that they sold was an infringement of copyright. Because if we allow that, we'll shut down the whole internet. It's not workable. The way the law sees it, if you have a website and someone's putting up videos or things like that, as long as you're not involved in creating the video or editorializing on the video, editing it, things like that, why should you be brought in to a lawsuit just because somebody else infringed when they created that video? So the concept is that there is an immunity. Admittedly, it's a limited immunity for certain types of ISPs and website hosts from contributory infringement of third parties' acts. So long as you adhere to the protocols of the Digital Millennium Copyright Act. One of the things you need to do is take it down. And this is the misconception. People think that it has to come down and stay down just because somebody alleged that there was a violation of copyright. That's not true. while it may be that in practice, if you're dealing with thousands of videos and things, it just doesn't make sense for you to put it up and deal with the potential problems. Just take it down and there'll be another 100 before day's end to replace it. And that may be a utilitarian reason why you keep it down. But the statute itself does not say that. The statute itself says it's a very short window, something like 10 to 14 days for the person who's saying this is infringing to then go forward with a lawsuit. And you could even have a counterfiling in which somebody files and says, no, that I'm giving you a counter notice that what this person said in their notice was incorrect. And so the point is that the DMCA takedown notice, the fact that it's going down is the first word, not the last word. And that material could go right back up again if, in fact, there's no enforcement action, legal enforcement action as such, and there's no activity beyond the notice. And I should add one more thing, which is super important for your audience to listen to, and that is there is liability if you issue a DMCA notice, a takedown notice, and you had no basis to do it. And that's super important. So if you're doing this for a different reason than you actually know it's infringing, you're creating a lot of problems for yourself. And there's all sorts of language in the statute to prevent just that sort of thing.
So if I understand what you're saying correctly, if someone says, hey, you're infringing, and you're actually not, they know you're not, and it's just, I want you to take your stuff down so that I can promote my stuff without competition, that's a problem. That's a big problem, and they can be liable. There can be real liability for doing it. The law considers that something along the lines of bad faith, and it's taken seriously. I'm glad that is. I think that definitely should be, because, there could be a lot of abuse of that DMCA if that wasn't in there. When you think about it, the internet is one of the triumphs of our age. It is a massive, massive utility, essentially, which is not regulated as a utility. The government does not run it. Mm-hmm. There are people who volunteer to keep the internet not just flowing, but to have it be robust, to be sure that information can move along the internet, where they're not even being paid to do that. They're just cooperating in creating this massive communication web. Part of what the government is doing when it passes the Digital Millennium Copyright Act is saying, we're not the police of your content. You're the police of your content in the first instance. If you need us to help you enforce it, you come to court, that's fine. But it's not like we're trolling the internet to find people who are infringing on copyright. That is self-policing. That is your obligation to find people who are violating your rights and take the initial steps under the DMCA. Once that's done, then you can avail yourself of the courts. Circling all the way back around to our beginning conversation, that's what a Scrum team does. They are a self-policing, self-regulating group. And our final question kind of actually has to do with something you've already mentioned about people volunteering their time and helping out. What's the best way for developers to sort of make sense of open source licenses, especially when evaluating components to use in an application? Well, when you're talking about open source, again, one of the misconceptions that people have is that it's all the same. That essentially open source means free, I can do whatever I want, and there are no residual rights that the developer of the open source code has. And that is not true. It's an oversimplification. The fact is that you're dealing with certain open source code where certain parts of it can be utilized without a proprietary right in the developer, and other parts cannot. Where when you create new applications, new things with this source code, there could be residual rights that the original developer of the open source code has. And so the question is it weak or strong? Is it permissive or strict? These are legal terms for the ways in which you can utilize or not utilize it. Do you have to, for example, put in copyright notice protection on this? Things along those lines. And I think that the big part of this, the thing that is really important, is to focus on not just
whether you can use the open source code for your own purposes, but the sale of it, the way in which it is being sold, let's say on the internet, whether that raises another level of permission that you have to have from the original developer such that you can protect it through copyright. Example being, let's say I use open source code and I create this wonderful application or website or whatever, and then I copyright the application, I copyright the website. What exactly am I copywriting? And do I have complete rights in that application or end product? Or are there residual rights that others have that I may not even be aware of, that where I might even have the copyright registration go through by mistake? The government might say, they may not have asked all the questions they need to ask or caught it, but does that really mean that I own it? Or that the person I'm selling it to, that I'm licensing it to, for example, has a complete license and they can just use it with impunity? Or that they can then take it and create something else with it, a variation on it, without getting permission. And so I guess the key, what I'm really talking about here is you must look at the specific terms and conditions by which that source code is being used and not ignore the conditions that are incumbent upon people who are using this, who are developing things with it. Very important.
Guys, Gary has been kind enough to come on the show and share his expertise. I'll be honest, even had Will and I both gone full med student, we would not have been able to cover half the material that Gary has shared with us. We do want to point out that something Gary said earlier, this is for educational purposes and shouldn't be considered legal advice. Our aim here has been to hit on some of the most relevant legal issues that developers face and may not fully understand. I know Will and I both have a much clearer picture of almost everything. I felt the whole time I should be typing up notes like I was sitting in a classroom while he was talking. I learned so much. Gary, we really want to thank you for coming on the show.
Well, thank you very much. And, as you can tell, I hope it's come across. I have a tremendous respect for developers. My son is a developer. I really think that what you do is fascinating, and it's really on the side of the future. I can't give legal advice without being retained, obviously, but my website is GDN Law, GaryDavidNancyLaw.com.
That pretty much wraps us up. Before Will gets into tricks of the trade, we want to invite everyone in the Nashville area out to Bar Camp Nashville Conference.
Bar Camp Nashville is a free annual gathering of the local tech community to learn, share, and connect.
Yeah, it's a day for sharing your passions and discoveries and exploring new interests.
Bar Camp is a user-generated unconference allowing anyone to participate as a presenter, organizer, or volunteer.
It's an opportunity for those who found success and failure to share their experiences and learnings with others to help grow and strengthen the Nashville tech community.
This year it will be held October 21st from 8 a.m. to 5 p.m. at the Tech Hill Commons. That's the same building as Nashville Software School, by the way. There will also be an after party.
Yeah, Will and I, along with the Junior Developer Toolbox crew, will be there at our booth and also recording interviews in the podcast lounge. Follow the link in the show notes to register and vote for the talks that you want to see. So, Will, what do you have for us this week for Tricks of the Trade?
Well, I'm going to do something a little odd, I guess, and that is to drive home the point that panic is kind of lethal. It's dangerous, especially if the situation has legal or health ramifications. I had that incident with the snake Friday night, and the thing is it was not a dangerous snake, but I could have injured myself had I assumed that it was and freaked out, and it would have been a great way to fall and hit my head. And I think a lot of people have very similar reactions to getting a communication from a law office that they do to suddenly finding a snake in the bathroom. There's the shock, there's the fear, there's this panic, and then they flail around and they end up hurting themselves. And I just want to reiterate the point that the lawyer is there to fix, they're getting paid to fix a problem for their client. They're not getting paid to create a problem for you. if you can remember that when you're having these interactions, and if you're having interactions with other professionals as well, and other capacities, you'll realize that it's a lot easier to deal with them from that angle, as opposed to a fear-based, panic-based approach. And you might just find that, hey, they're doing their thing, you're doing yours, and just a slight change in behavior gets rid of the problem, and everybody's fine. And that's pretty much all I got.
Thank you.
Stand by for Titanfall.
If you have a question or comment, please email us at neckbeards@CompleteDeveloperPodcast.com. Our theme music is an excerpt from Stand By for Titanfall by Pure Bells, available on SoundCloud and licensed through Creative Commons. The intro music for IoTs is Hillbilly Hip Hop by Jason Belcher. For references, show notes, and to sign up for weekly emails with extra tips and insights, be sure to check out the website at CompleteDeveloperPodcast.com. You can also follow us on Twitter at CompleteDevPod and like our page on Facebook to keep up with news about the show. Look for us each week on Facebook Live before we record each episode. Thanks for listening. See you next time.